camera without breaking it. Oh. What did I do? I shrunk it. I don't know what to do it. Can you see me? I'm a mess. But anyway, I had a cheddar wurst, so I feel a little better. Welcome to No Crime, No Time. This is part 2 of the ruling from the Court of Appeals denying Avery. So we're going to jump into it here in just a minute. I just want to make sure everybody's coming on board and that we're broadcasting okay and that you can hear me. Then we're going to get going. We're going to, if you're following along in the documentation and the actual filing, we're on motion 2. We're starting with October 2017 motion for relief from order. And it is on page 28. So, nose itched. I'm hearing a weird sound. It was like somebody must have, I don't know. Zelma Lopez and Kind. Yeah, I feel a little better. Thank you for inquiring. I do. I was hungry. I was getting hangry. It didn't help. I was eating that for breakfast, reading this. But now I feel better. All right. Let's go ahead and get started. Hey, Jennifer Manning. Love you. Bakachua. Good morning. You do such a beautiful job, lovely. I support everything that you're trying to do here. We're all on the same page. We just, we got to keep plugging away here. So there is some hope here. There is. So this isn't the finale, All right, let's get rolling. Maya, can you not clean your paw the entire time I try to read this? She's like obsessed with her paws today. Motion number 2, October 2017 motion for relief from order. Section 49. Hey, Cheshire, love you, baby. 3 days after the circuit court denied his Wisconsin statute 974.06 motion, Avery filed a motion for relief pursuant to Wisconsin statute 806.071A. The stated basis for this motion was that a month prior to the court's order, defense counsel and prosecutors had agreed to additional testing of Halbach's RAV4 and of bones found in the Manitowoc County gravel pit. That the parties had agreed that Avery would amend the June 2017 motion, and that Avery, quote, intended to inform the court that an amended motion would be filed, but, quote, did not anticipate the court filing its order before he could do so. So the subsection that it's referring to is, on appeal, Avery implies that the state misled him about the need to expeditiously inform the circuit court of his wish to amend, supplement the June 2017 motion. For example, Avery states, quote, when current post-conviction counsel inquired as to whether the circuit court should immediately be informed of the agreement, the prosecutor stated that once he had finalized the scheduling of the RAV4 examination, a stipulated order could be presented to the circuit court. The statement appeared to be Avery's counsel's own unincorporated description of events. There is no basis in the record for this or any relevant argument that the state misrepresented the post-conviction process. In any case, as the circuit court explained, the state cannot determine whether or how motions to the court are amended or supplemented, and Avery had no grounds for assuming otherwise. Moreover, this argument was not presented to the circuit court and is therefore thereby forfeited. See Hubener. Accordingly, we address this point no further. Excuse me. The circuit court denied the motion, explaining that after receiving the June 2017 motion, no communication was made requesting that the court withhold its final decision or indicating that the original motion was incomplete and would be supplemented. The court acknowledged that the defense and prosecution might very well have discussed amending the June 2017 motion in anticipation of the court's granting a hearing, but the court was not informed of any such negotiation until after the final ruling in this matter had been issued. None of the agreements were submitted to the court for its approval until after the final decision was made in the defendant's original motion. It is for the court and not the parties to determine if amendments to motions previously filed will be permitted and to establish scheduling for matters pending before it. Agreements should have been submitted for approval for the court prior to the final decision on the original motion being reached. The defense cannot try to amend a motion that was filed without reservation only after it receives an adverse ruling. Wisconsin Statute 806.071A provides that the court, quote, may relieve a party from a judgment, order, or stipulation for mistake, inadvertence, surprise, or inexcusable neglect. We review the circuit court's decision on a motion for relief under 806.07 subsection 1 for an erroneous exercise of discretion, meaning we will sustain the court's ruling when it applied the appropriate law to the facts on record so as to, quote, archive a reasoned or reasonable determination. Milwaukee's Woman Medical Service Incorporated versus Schindler. As explained above, a movant is not entitled to an evidentiary hearing merely because he or she filed a Wisconsin Statute 974.06 motion. In the typical case, the circuit court will evaluate the final sufficiency of the motion before ordering the state's response or scheduling a hearing. Romano, Georgiana. Thus, circuit courts routinely receive and deny 974.06 motions where there is no basis for a hearing. As one would expect, courts are not required to, and generally do not, update the movant about when a decision on the motion is forthcoming. Avery appears to acknowledge these. Excuse me. My throat chakra hates reading this. Avery appears to acknowledge these basic principles of post-conviction procedure. Nonetheless, he argues that the circuit court erroneously exercised its discretion here because in denying his motion for relief, it ignored the existence of the 2007 order. This 2007, quote, order on preservation of blood evidence and independent defense testing directs the state to preserve swabs and blood stain samples collected from the RAV4 and containing Avery's DNA and allow such items to be submitted for independent testing without further order of this court. Excuse me. Avery's agreement with respect to the 2007 order misses the mark entirely. Even if all the items that parties contemplated testing in 2017 had been described in this order, the order has no bearing on the presentation, timing, or amendment of any Wisconsin Statute 974.06 motion. Excuse me. The circuit court correctly concluded that it is not required to revisit its decision on the June 2017 motion upon being belatedly informed that Avery wished to amend that motion. Thus, the court did not erroneously exercise its discretion in declining to vacate an order adverse to Avery so as to allow amendment of a motion that was filed without reservation. Motion number 3. October 2017 motion for reconsideration. Shortly after filing his Wisconsin Statute 806.07 motion, Avery filed a motion to reconsider. As relevant to this appeal, he alleges that newly discovered evidence warrants reconsideration of the court's denial of his June 2017 motion. A party may prevail on a motion for reconsideration for presenting newly discovered evidence, but such motion is not a platform to introduce new evidence that could have been introduced as part of the original proceeding. Capsule Old Popcorn Wagons Incorporated versus Capsule's Festival Popcorn Wagons. The term newly discovered presupposes that the evidence was unknown at the time of final judgment. That is, it was not under the control or knowledge of the movement and discoverable by reasonable diligence. We review a trial court's decision on a motion for reconsideration under the erroneous exercise of discretion standard. A motion for reconsider on the basis of new evidence would seem to be a doubtful utility in cases like this, where the movement is free to file successive motions. See Wisconsin Statute 974.06, subsection 2. Nonetheless, we perceive no legal barrier to Avery's bringing such a motion, and the state does not argue as much, except to point out that this motion cannot be the means of avoiding the procedural bar of Escalona Navarra. In this context, to be entitled or reconsideration of the basis of newly discovered evidence, the movement must show that the evidence was unknown and not reasonably discoverable when the first 974.06 motion was filed, and that the evidence reasonably relates to those claims brought in the first motion. Alternatively, the movement may simply bring a new 974.06 motion and just demonstrate his or her sufficient reason for not raising the claim in prior 974.06 motion by showing that the evidence underlying that claim was the unknown and unreasonable discovery. Avery makes no showing in his motion to reconsider as to why he could not, with reasonable diligence, have included this new evidence in his June 2017 motion. Instead, he uses this third motion as a vehicle for raising new claims. None of these claims or evidence, however, have any bearing on the claims raised in June 2017 motion. So it is unclear which original claims the circuit court was being asked to reconsider, or why. In any case, the majority of this evidence cannot reasonably be considered unavailable or undiscoverable at the time Avery filed his June 2017 motion, nor if we simply treat this motion as a new Wisconsin Statute 974.06 motion does Avery demonstrate why these claims are not procedurally barred under Escalona Navarra. Setting aside the question of why the claims were not alleged in the June 2017 motion, Avery has not explained why these were not alleged in the 2013 motion or on a direct appeal. Section 59. We do note that buried in the motion are two claims based on evidence that appears on the face of the claims to be newly discovered, according to Avery. In October 2017, his sister Barb Tadich, who lived on the Avery property and whose son, Bobby Dassey, Avery, identifies as an alternative suspect in the crime, told him two pieces of information that would impeach her son's testimony about last seeing Halbach walk toward Avery's trailer on the day of her disappearance. In Avery's view, the sister, quote, admitted that she knew the Halbach had left the property on the day in question. This evidence, however, is equivocal and does not clearly establish that Halbach in fact left the property on the day of her death, or that any witness was aware of or lied about the fact of at the trial. Moreover, the evidence does not bolster any claim in the June 2017 motion, 2017 motion, so as to warrant reconsideration of that motion. Even viewed on its own merits, the evidence does not entitle Avery to a Wisconsin Statute 974.06 hearing because he has not shown that that is material. See Edmonds 308, Wisconsin. At best, we have two unsworn statements by Barb Tadich that Dassey told her something that is potentially inconsistent with his trial testimony. This is hearsay that would have been inadmissible at a new trial, meaning that it cannot constitute newly discovered evidence as a matter of law. See State versus Bimbanek. They brought up Bimbanek. You know what that means. I'm going to have to revisit the Bimbanek case. Wow. All right. Section number 60. How many's with me? Y'all with me? Everybody with me? All right. One drink. Here's a toast to keeping our chin up, staying strong, taking a deep breath and moving forward. With you, hi, kind. Good grief, Chester Mercury says. Claudia knows. Weasels. I hear you, lovely. All right, you guys. Subsection. I know, Mary. They brought up Bembenek. I do have a video out there about Bembenek case. I think there's a couple, and I'll probably revisit it. I might learn more. Jess, hi. Jess, Maria. Cheers to all of you. Hey, Michelle Stratford. Welcome back. All right, lovelies, let's keep going. We're on section. If you're following along, actually, on the filing itself, I'm about to read subsection 60. And where's page 35 of 49. Grandma's here. Love you, Noah. Have a good time at Grandma's. Sorry, I just screamed. Jess Marie. Aw. It's going to be really loud for a minute because Grandma's here. They're going to go get malts at the ice cream shop. Oh, to be a kid again. All right, lovelies, here we go. Subsection 60. Avery chose to frame these claims in the context of a motion to reconsider, but without applying that legal standard or, in the alternative, explaining why he had a sufficient reason for not bringing the claim in previous motions pursuant to Escalon and Navarra. As discussion in the above section on the June 2017 motion, we're willing to give Avery the benefit of the doubt where possible as to why he did not raise certain claims in 2013 or on a direct appeal. But we cannot ignore the law, and thus we cannot simply determine whether the merits of his motion to reconsider claims warrant an evidentiary hearing, whereas the only narrow question before us is whether the circuit court erroneously exercised its discretion in not reconsidering the June 2017 motion on the basis of the purported new evidence contained in those claims. We conclude that the circuit court did not erroneously exercise its discretion in denying this motion. The court noted that Avery provided no explanation for filing. Thank you, Kevin. Buy myself a drink. You know what, Kevin? I am probably going to get myself a nightcap tonight. I might. Thank you so much. We concluded that the circuit court did not erroneously exercise its discretion in denying the motion. The court noted that Avery provided no explanation for filing the June 2017 motion while, quote, considering investigation was still being conducted by the defense. This explanation is reasonable and sound and represents an appropriate exercise of discretion. Motion number 4, July 2018, supplemental motion. Subsection 62. Avery appealed from the Circuit Court's October 2017 and November 2017 orders denying his June 2017 motion and his motions to vacate and reconsider, respectively. In May of 2018, Avery moved this court directly, quote, to supplement the record on appeal with a CD disclosed to defendant for the first time on April 17, 2018. Avery asserted that sublimation of the appellate record was appropriate because the contents of the CD related to the claims already presented to the circuit court. We stated that this assertion, quote, misses the point, which is that we are not fact-finding court and cannot consider items not presented to the circuit court. We determine, however, based on the assertion that Avery recently received previously withheld discovery or other new information, we retain jurisdiction but remand the case to enable Avery to file an appropriate supplemental post-conviction motion in the circuit court within 30 days of the date of this order. The circuit court shall hold proceedings on the supplemental post-conviction motion within 60 days of the motion is filed. In July of 2018, Avery filed his motion to supplemental the July 2018 motion alleging a Brady violation. Recall that prior to trial, Avery unsuccessfully moved to introduce third-party liability evidence pursuant to State versus Denny. In his July 2018 motion, Avery alleges that the state withheld significant evidence both favorable to his Denny motion and relevant for impeachment purposes. A final investigation report of Detective Mike Billy, saved on a CD, the Valley CD. Valley created the report through forensic examination of the hard drive of a computer used by Dassey, whom Avery identifies as a possible Denny suspect. The Valley CD contains, quote, thousands of images of violent pornography that Avery argues, quote, reveal a propensity for sexual violence by Dassey. Avery elsewhere attempts to explain. All right, Jessie Marie, get some rest, lovely. I've seen the camera flashes while I look up. Avery elsewhere attempts to explain why, of several people who use the computer, only Dassey could have downloaded these images. The CD also contains a timeline that purportedly impeaches Dassey's trial testimony and criteria, word searches, registry, recovery pornography, internet history, Windows registry, and all MSN messages. According to Avery, he did not receive the Valley CD until April of 2018. Subsection 64. The circuit court determined that there was no Brady violation because there was no evidence suppressed. We agree. It is undisputed that the computer was examined and its contents copied to 7 DVDs. It is undisputed that Avery's counsel received these 7 DVDs prior to trial. Finally, it is undisputed that with limited and irrelevant exception, the Valley CD does not contain any additional information than what is on the 7 DVDs. Consequently, the Valley CD is not suppressed evidence, but merely an investigative summary of evidence provided to Avery. Subsection 65. Avery appears to acknowledge these facts on appeal, but argues that he should have had access to information derived from Valley's unique word searches, pornographic images refined for relevancy, and the like. This is not the law. Brady on its terms applies to favorable and material suppressed evidence. And Avery represented no authority extending this principle to the prosecution's withholding of secondary complications. I can't say it right now. It's not complications. Withholding of secondary whatever, or analysis of such. See United States versus McGinnis. Brady applies only to the facts that are not already known by the defendant. The government need not facilitate the compilation of exculpatory material that, with some industry defense counsel, could marshal on their own. I need a minute. My mind's starting to blur with all the double talk, as always. This has been the longest read. Subsection 66. We push on. Avery raises two related arguments concerning the disclosure of the DVDs themselves. He argues that the state deliberately misled him about the importance of the DVDs by stating in an email that they, quote, did not include much of evidentiary value. Even if the statement mischaracterized the evidence, however, an off-the-cuff description of disclosed evidence cannot form the basis for a Brady violation. Avery further argues that he was only provided the DVDs approximately 1 month before his Denny hearing, leaving him, quote, completely impaired in his ability to introduce relevant evidence in that proceeding. But this argument properly concerns alleged ineffective assistance of trial counsel, see below, because such conclusory statements do not adequately explain why trial counsel could not have analyzed the DVDs in time for the motion hearing, sought to postpone the hearing, or taken any number of other steps to effectively leverage this evidence. That's because we had ineffective counsel, which they just proved. All right. Subsection 67. My eyes are getting blurry. In the July 2018 motion, Avery did indeed argue that trial counsel was ineffective for failing to forensically examine the 7 DVDs prior to trial. He does so summarily, however, and in a manner that leaves us unable to meaningfully analyze his claim regarding potential use of this evidence in his Denny motion. Avery does not address the prejudice prong of the Strickland test, which in our view encompasses at least 2 key inquiries. To admit evidence at trial that Dassey could have killed Halbach, Avery would have had to provide some evidence to the pretrial dinner hearing directly connecting Dassey to the crime. See State versus Scheidel. Evidence that another party committed the crime may be admissible pursuant to Denny if the defendant can show, number 1, the third party's motive, number 2, the third party's opportunity to commit the crime, and number 3, some evidence directly connecting the third party to the crime. That Dassey possibly possessed violent pornography images might have conceivably satisfied a separate requirement, motive, but is insufficient in and of itself to allow admissible of third-party liability evidence. Avery failed to meet the direct connection requirement in his original Denny motion and has not presented additional evidence on this point in motion number 4. Thus, even assuming trial counsel was deficient in not analyzing the DVDs, Avery cannot demonstrate a reasonable probability of a different outcome of the Denny hearing or at trial. Regarding the use of this evidence for impeachment purposes, even accepting that the CD contains a timeline that impeaches Dassey's trial testimony, we're skeptical at this point, see note 25. Avery does not explain how impeaching Dassey about his use of the computer would have changed the outcome of the trial. At most, the jury would have disbelieved Dassey's testimony that on the day Halbach last visited the Avery property, he saw Halbach walk towards Avery's trailer. He did not see her leave the property. Halbach's RAV4 was in the driveway when he left going to hunting, and the RAV4 was gone when he returned several hours later. Avery identifies these as the key pieces of testimony. Certainly, these testimony bolster the state's theory that Halbach visited Avery on that day and did not leave the Avery property thereafter. But absent thus testimony, the state still possesses significant forensic and other evidence implicating Avery in a crime committed on his property. Without any showing or argument as to why the impeachment of Dassey would have undermined the cumulative effect of the other evidence, we cannot conclude that the trial's outcome could have been different. We conclude that the circuit court did not err in denying the July 2018 motion without a hearing. Motion number 5, March 2019 supplemental motion. Subsection 69. If you're following along, we're on page 42 of 49. Hi, Mini-Man. In January 2019, Avery again moved this court directly to stay the appeal and remand for the circuit court's consideration of specific claims relating to the state's 2011 related to Halbach's family of suspected human bone fragments. We determined that, quote, given the specific circumstances of this case, we would stay the appeal and remand pursuant to Wisconsin Statute 808.75 for action on this issue. We again ordered remand to the circuit court to permit Avery to pursue a supplemental post-conviction motion on specific claims, and we directed the court to conduct any necessary proceedings. The circuit court denied the motion without a hearing. The gist of motion number 5 is that the state release to the Halbach family suspected human bone fragments recovered from the Manitowoc County gravel pit, thereby violating, number 1, a circuit court order, number 2, Wisconsin Statute 968.205, requiring the state to preserve certain biological material evidence connected to a criminal conviction, and number 3, Avery's constitutional rights. As a Wisconsin Statute 974.06 motion may raise only jurisdictional, constitutional, and like claims, we considered only the third argument. Avery alleges that in 2011, the state improperly released the Halbach family bone fragments from the gravel pit, which Avery wished to test to determine if they contained Halbach's DNA, might therefore or thereby indicate that Halbach was not killed on Avery's property. Avery argues that the state, by its actions in returning the bones, has implicatedly admitted that the bones were not only human, but they belonged to Mrs. Halbach. Avery frames this as a violation of Arizona versus Youngblood, under which a defendant's due process rights are violated where the state either 1, fails to preserve apparently exculpatory evidence, or 2, acts in bad faith by failing to present potentially exculpatory evidence. See State versus Greenlaw. Avery represents that he was not aware and could not reasonably have been aware of the release of the bones until after he filed the fourth motion. We will assume, therefore, that this claim is not procedurally barred under Escalona, Nevada. The state argues that the Youngblood analysis only properly applies to the destruction of pretrial evidence. We agree generally, but need not explore this point because Avery's claim fails on its own terms. The premise of Avery's argument is that the state released to the Halbach family evidence that was either apparently or potentially exculpatory bone fragments from the gravel pit that may have been Halbach's. The evidence, when first collected, was labeled as containing some human bone fragments. At trial, however, the undisputed testimony of the state's forensic anthropologist was that, on further analysis, the bone fragments could not be definitively identified as human, much less as belonging to Halbach. On this record, therefore, this evidence is not apparently exculpatory. It does not indicate that another person killed Halbach. See Youngblood. Evidence is not apparently exculpatory where those having custody over it did not know of its exculpatory value, and the evidence, quote, was simply an avenue of investigation that might have led in any number of directions. Nor can Avery establish that this evidence is potentially exculpatory because even assuming that these bone fragments are Halbach's, Avery does not explain the significance of this fact. This apparent thrust of Avery's claim is that if Halbach's bones were found in the gravel pit, then she was killed by someone else. But as Avery never explains why he himself would have been unable to dispose of Halbach's remains in the gravel pit, this line of reasoning is wholly speculative. Moreover, Avery cannot show bad faith, meaning, number 1, the officers were aware of the potentially exculpatory value or usefulness of the evidence they failed to preserve, and 2, the officers acted with official animus or made a conscious effort to suppress exculpatory evidence. See State versus Rubberducky. The record reflects that the state released bone fragments of undeterminate origin after Avery's direct appeal was fully litigated, When there appeared no direct of immediate need to preserve this evidence, and contrary to Avery's argument, the very fact that the state released the bones does not mean that these are hawbucks, or that the state acted in bad faith to, quote, destroy this evidence. The Hawbuck family requested these bone fragments for purposes of its own, likely for closure, but that does not vest these fragments with evidentiary significance. I just lost my place. I accidentally clicked something and it changed my page. Oh, Lord, I'm way back on 22. Hold on. What page were we on? Anybody know? I literally just jumped. I thought we were on like 40 something. Anybody know? I just lost my place. Okay, we're past the LCD part, obviously. We're into the bones of the hawbog. $57. I'm just reading to see. Okay, so I'm not that far. Like I clicked something. Oh, I think I'm here. Okay, what we're going to do. We're just going to start right here. Subsection. I know I read that part. Okay, I know where I am now. We're on page 45. Okay, so we're going to start this section over. I think I did it, but we're going to do subsection 75 on page 45. Okay. Nor can Avery establish that this evidence is potentially exculpatory, because even assuming that these bone fragments are hawbucks, Avery does not explain the significance of that fact. The apparent thrust of Avery's claim is that if Hawbuck's bones were found in the gravel pit, then she was killed by someone else, but as Avery never explained why to himself, would have been unable to dispose of Hawbuck's remains in the gravel pit. This line of reasoning is wholly speculative. Moreover, Avery cannot show bad faith, meaning, number one, the officers were aware of the potentially exculpatory value or usefulness of the evidence they failed to preserve. And number two, the officers acted with official animus or made a conscious effort to suppress exculpatory evidence. The record reflects only that the state released bone fragments of indeterminate origin after Avery's direct appeal was fully litigated, when there appeared no direct or immediate need to preserve the evidence. And contrary to Avery's argument, the very fact that the state released the bones does not mean that these are hawbucks or that the state acted in bad faith to destroy this evidence. The Hawbuck family requested these bone fragments for purposes of its own, likely for closure, but that does not vest these fragments with evidentiary significance. Motion number 6, Avery 2021 motion to stay and remand, subsection 76. Let's get a drink. On November 9, 2020, we notified the parties that this case had been submitted to the court for decision on briefs. On April 12, 2021, Avery filed another motion with the court to stay his appeal and remand for evaluation of the new claim. This claim concerns an alleged Brady violation, the factual basis for which Avery purportedly obtained on April 11, 2021. Specifically, the claim is based on the affidavit of Thomas Lewinsky, a Manitowoc motor route driver, who attests that days after Hawbuck's death, while on his paper route in the early morning hours, he spotted a shirtless Dassey and an unidentified older man pushing Hawbuck's vehicle down Avery Road towards the junkyard. Lewinsky causing him to swerve. Whoops, I jumped a line. Lewinsky further attests that After he delivered the paper, Dassey attempted to block his exit, causing him to swerve and drive into a shallow ditch. Slowinski claimed to have called the Manitowoc Sheriff's Office later that day to report what he had seen, but was told they already knew who did it. He also claims to have attempted to contact Avery's trial attorneys after season 1 of Making a Murderer, but never heard back from them. When Avery filed this motion, we had already twice stated his appeal, each time because he asserted that new claims related to those previously litigated and that it would be more expeditious to resolve them as part of the instant appeal. By the time Avery filed the new motion, however, we had already evaluated the legal and factual basis of the claims already raised. We therefore were and are in the position to conclude that this newly raised Brady claim bears little or no relation to those claims already before us. This is instead a distinct issue that the circuit court should resolve on a standalone basis through Wisconsin statute 974.06. Okay. I want to pause there. This is important. We therefore were and are in the position to conclude that this newly raised Brady claim bears little or no relation to those claims already before us. So they're saying that claim needs to be addressed. They're saying it needs to be addressed. That's good. That's good, you guys. Okay. They go on to say this is instead a distinct issue that the circuit court should resolve on a standalone basis through a new Wisconsin statute 974.06 motion. All right. Subsection 78. Moreover, Avery's last motion arrived while our decision on his appeal was forthcoming. It would be an insufficient use of the court's resources to now and once again delay the appeal's resolution. We appreciate that Avery likely wishes us to consider this new Brady violation claim in the context of claims previously raised, but we must weigh that implicit consideration against those discussed above. Simply put, Avery's appeal cannot continue indefinitely. Accordingly, the decision operates as an order denying Avery's April 12th, 2021 motion to stay in remand. If Avery wishes to raise this claim, he must file a new Wisconsin statute 974.06 motion with the circuit court. Pursuant to Escalona Navarra, Avery will need to demonstrate why he could not have previously raised this claim, including in his June 2017 motion, before the merits can be reached. Good God, we have reached a conclusion. Avery raises a variety of alternative theories about who killed Haubach and how, but as the state correctly notes, a Wisconsin statute 974.06 motion is not a vehicle to retry the case to a jury. A criminal defendant is constitutionally entitled as of right to a jury trial, and if convicted, a direct appeal. If he or she later seeks a collateral attack, the conviction on the constitutional or jurisdictional grounds, a 974.06 motion is appropriate. But key to any 974.06 motion are sufficient non-conclusory showings, both as to why the issue was not raised in an earlier post-conviction proceeding and why the claim has factual merit. These requirements are not optional and cannot be met through broad conclusions or by mistaking evidence. We express no opinion about who committed this crime. The jury has decided this question, and our review is confined to whether the claims before us entitle Avery to an evidentiary hearing. We conclude that the circuit court did not erroneously exercise its discretion in denying hearings on motions number 1, number 4, and number 5, in not vacating its order on motion number 1, and in not reconsidering its ruling on motion number 1. As for motion number 6 and to the portions of motion number 3, the motion to reconsider, raising new claims, we leave open the possibility that Avery may raise these claims in a new Wisconsin statute 974.06 motion. We remind Avery, however, that he will need to overcome the Escalona-Navarra procedural bar on these claims, which includes providing a sufficient reason for not raising them in his June 2017 motion. Moreover, Avery will need to satisfy the previously discussed we started with it and we end with this word, specificity requirements, specificity. They're just making shit up. Requirements before such claims may proceed to a hearing. See John Allen. By the court ordered confirmed, this opinion will not be published. And it is signed. All right. I'm done. I'm done reading. I'm done reading all of it. Yeah, Nance Life says Zellner's likely drafting that motion right now. You know, let's just look at that. Let's just take that 974.02. What's that say? Yeah, if we do a 974.06 on this, where we have the eyewitness seeing Bobby pushing the blue RAV4, you would think, I mean, I'm not a lawyer, but I feel like there's no way around that. Why would we have not had it any other time? Why would it have never been brought up? It was because we didn't have that information. It wasn't available. And what was their other criteria? Because it was 2. And hell yeah, that would sway some juries. It's very likely if they had heard an eyewitness say, well, Bobby Dassey was pushing the blue RAV4 onto the Avery property, that would have turned some heads. So what do we need to? We remind Avery, however, that he will need to overcome the Escalona-Navarra procedural bar on those claims, which includes providing sufficient reason for not raising them in his June 2017 motion. Well, we didn't know about it. Moreover, Avery will need to satisfy the previously discussed specificity requirements before such claims. I really think that's important. Hey, Sherry Lynn, good to see you. You guys do some talking. Come on in. I want to say thank you to all of you that sent me super chat during that. That was so sweet. I do appreciate it. Yeah, Sherry, I feel you. Sherry says she knew this was going to happen. There's a window. There's a window to the wall. Ugh. Okay. So, I don't know. The walking away, I guess, was the Court of Appeals. You know, they just walked away. They were like, yeah. It is what it is. We just have to stay strong. We got to keep rolling. I'm going to be recording a blackout tonight. I don't know if it'll be uploaded tonight or tomorrow night, but it's going to be, oh, you are so welcome, Cheshire. I appreciate you guys listening. I'm going to read it anyway, and I want to understand it. And I actually feel like when you guys are with me, I retain more of it because I'm trying to make sure that I'm understanding it with you. That's right, Nan's Life. Never give up for all the victims. You like the blackouts, Sherry? A lot of people love the blackouts. I get so much, like, I think people are afraid to be too supportive in front of others because Apparently, some people give a shit what other people think. I don't. Um, but they send me so much encouragement on those blackouts. And I feel that they do a lot of promoting us to really look at the situation in a way that your mind has to kind of like participate. You can't just blindly listen to it and not feel yourself trying to put the dots. Sorry, I didn't mean to bump the table. Not put the dots together. So it feels to me, the blackouts tend to pull you in so that you're actively putting the dot to dot of the big puzzle together. Yeah, so I'm excited about this blackout because this one's going to, it puts things in so much light because of trying to, so I was following the officers, their time logs and their reports to see, like, if I literally was like, here's this guy, and then he went here, and then he went here, and then he went here, where logistically it would put him on what day. Now, I couldn't do it by time, really, not down to a science, but I could kind of pinpoint on this day, on that day, this individual was like here, 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 and here. Well, when I did that, it crossed the path of something big, big, huge, huge, huge. And it's going to leave you guys kind of going, what the, yeah, what the beep. So I want to make sure and walk through it appropriately with you. I do encourage you guys to be respectful and just encourage you to do your research. If I say something that is off, I mean, I've said Uyghur instead of Fassbender sometimes and stuff like that. Please do correct me. I just ask that you show the same respect that I give to you guys. What time is the blackout? I usually throw them out there around 8 p.m. So it will probably be, well, actually, there really is no time. I think I've thrown them out there at 1 in the morning. Hey, just if you want to know, hit the little, what is that called? There's a little icon. It's the bell. And I think you can do something like right click it and choose something and whatever. It should alert you. And then if you don't want to do it after that, you can take it off. Right. And Nan says, don't ever, Nan's life, she's got such a good point. Let's read her comment and then I'll make my comment backing what she's saying because she's so on. She says, we've experienced so many what the F in this case, and it's important to dig and not just take someone's opinion. 1,000% on that. Okay? And never do we want to allow somebody to do what Kratz did and change our perception. Yeah, I don't want you to change your perception based on what I tell you. It might stir your curiosity to do your own research, but I don't want to be the cause of why you believe something. I want you to check it out yourself. It builds this so that it's what you know, not what somebody has told you. Yeah, there is still more. Yeah, so Sherry Lynn says the problem is, they were watching SA and listening unofficially to his phone because of the lawsuit. L.E. would have known Teresa was going to the salvage yard. Yep. So true. All right, my lovelies, we have been here for 53 minutes and 44 seconds. And I'm thinking I'll get off here so that I can get refreshed, get some housework done. Michelle says, no 1 a.m. for me. 8 p.m. will be good. Or 8 p.m. will be great. Cold case, like you have to wipe the state clean and start over with a fresh angle. I agree, Sherry. I'm going nice cold beer at this hotel just outside of London. Tip 1 up for me, Kevin. Thank you so much. Thank you guys for the super chats. Thank you, thank you, thank you, Kevin, and to all the others. I greatly appreciate it. Thanks, Raised by Gypsies. I love you guys. Hey, you guys, treat yourself kind today. Remember, this is just a battle, and we're not done. It's not dead in the water. We have lost one battle, and it was a big one. So, time to treat yourself kindly and treat others kindly too if you can. Do your best. I know people um, genuinely all have the same goal in this case that are truthers. So, hopefully, we can all strengthen each other, right? I love you guys. I love you to the moon and back. I love you, Zoner. Thank you guys. Bye. Oh, and if you didn't do the crime, you sure the hell shouldn't do the time.